Good morning. We're recording both on YouTube and to the cloud. So I just want to let you know.
Good morning.
Good morning.
Good morning, judges. Good morning, Liz.
All right. Liz, I know we have Mr. McSwain and Miss Keeney. Is that correct?
Yes, and
Mr.
those are
Olson.
the appellees. Appellant is Charles Osen.
Okay. Can you remind me, or do you know, Liz, how they're going to break up their time?
Yes, appellees are going to break up their time, 13 minutes for Mr. McSwain and 7 minutes for Miss Keeney.
Okay, because we're doing 20, 20, and 10.
Correct.
All right. I'm going to go ahead and let everybody in the room, and then you're going to announce court for us, Miss Liz?
Yes.
All right, thank you. I won't forget you this time. All right, I think we've got everybody on. My understanding is, I'm just going to confirm, Mr. Olson, you're going to argue for the appellants for 20 minutes. Mr. McSwain is 13 minutes. Ms. Keeney is 7 minutes, and then rebuttal for Mr. Olson is 10 minutes. Is that correct? Okay. All right.
I'm sorry. Forgive me. I was muted. It's correct as far as I'm aware.
Yes, that is, and I was as well. I apologize. That's correct.
That's no problem. We're all still learning. We're all still learning. That's fine. That's no problem. All right, Ms. Waters, can you announce court for us, please?
Yes. The Court of Appeals for the 8th District of Texas is now in session.
Thank you. And at this time, the court calls Central Texas Water Supply versus Kempner Water Supply and the City of Lampasas. And Mr. Olson, you may proceed.
Thank you, Your Honor. Good morning. May it please the court. This is a contract construction case, and the issue before the court is the intent of this water supply contract. What the intent was on the date the contract was signed in 2005. And it's significant that we talk about the intent on the date that the contract was signed. The contract deals with the treatment and delivery of water from a water treatment plant. And that term, I'll use that term during my discussion here. Water treatment plant is a defined term in the contract and is essentially the water treatment plant, the only water treatment plant that existed that was owned by Central Texas at the time. The water delivered from the water treatment plant through what is called the existing system, which was another defined term, and that was the water treatment plant and then all the pipelines and so forth that existed at that time in 2005 that was owned by Central Texas. So the contract was to receive water, treat it. The water came out of Lake Stillhouse, and we call it raw water. Receive raw water, treat it, and then send it out to Kempner. The contract speaks to the amount of water that Kempner Water Supply, and I'll refer to them as Kempner, was entitled to have treated. And it talked also about how Kempner would pay its fair share of the cost. Now, there are two types of costs that are involved in this action. One is what is called water treatment costs, and that is energy chemicals, that sort of thing, to actually treat the water. And then the other is called O&M, or operation and maintenance expenses. And those are things like fixing the pipelines, maintaining them, lubricating them, the staff that is used to pump the water and so forth. So water treatment costs and O&M. And all of this was the water treatment costs and O&M for the existing system, the only system that existed, and the water treatment plant, which was the only water treatment plant that existed at the time. Kempner had the right to receive up to 53, had the right to have water treated so that it would receive up to 53% of the water treatment plant capacity. So Kempner was the big player here. It was entitled to have more water treated and delivered than all of the other members of Central Texas combined. Now, when I refer to members of Central Texas, the record shows that Central Texas Water Supply Corporation is a wholesale water supply corporation. They don't deliver to mom and pop. They deliver to the small cities who then sell the water to mom and pop. And so the members of Central Texas are the customers of Central Texas, and they're also have a representative on the board. And the only exception to that is the city of Lampasas is not a customer of Central Texas, but does some historical thing that I'm not totally aware of, does have a place on the board. So all of the other, including Kempner, all of the other customers who receive water treated by Central Texas are also board members. Rather than pay a fixed amount, oftentimes in this business we see $3 per 1,000 gallons of water treated, that sort of thing. This contract is slightly, not slightly, significantly different in that it sets out a specific description of how Kempner is to pay its fair share of O&M and water treatment costs. It is clear from a reading of the contract that the intent of the contract was for Kempner to pay its proportionate share of those costs. When the contract was executed in 2005, it had several terms in it that are relevant to this suit, but let's start with sort of the ones that have gotten the most focus. Section 2.03 of the contract speaks to water treatment costs. How is Kempner going to pay for water treatment costs? Well, the first thing it says is that Kempner Water Supply Corporation agrees to pay the actual cost to produce, treat, and deliver water, so forth, from the plant. Now, the way it describes the actual costs is in light of the subject of this contract, and that is the existing system and the existing water treatment plant. The production costs charged to Kempner will be prorated based on the annual number of gallons of treated water received by Kempner as a percentage of the total number of gallons of treated water received by all Central Texas customers. At the time this contract was signed, the subject being the existing system and existing water treatment plant, what that meant was the production costs charged to Kempner will be prorated based on the annual number of gallons of treated water received by Kempner from the water treatment plant, because that's all that existed, as a percentage of the total number of gallons received by all customers from the water treatment plant. Those were the conditions that existed when the contract was signed. Section 2.05 speaks to O&M costs, operation and maintenance costs. And again, these are the operation and maintenance costs. The only thing it pays for is operation and maintenance of the existing system, which includes the water treatment plant. And the same thing, if it uses 50% of water in a given month, if it has the water treated, the plant capacity and the amount of water that comes out of the plant, if 50% of that water in a given month is delivered to Kempner, then Kempner pays 50% of the cost. It is a fair concept, straightforward, simple. It is exactly what a reasonable business person would expect. You take 45% in a month, you pay 45% of the costs. Nothing unreasonable whatsoever about that. In addition, Kempner reserved the right in the contract to reduce the amount of water that it was entitled to take.
Counselor.
Yes, sir.
I'll tell you what bothers me about this is when you read the contract, it certainly contemplated, or somebody contemplated, that there might be new facilities in the future. I mean, there's within some of the terms, they talk about the possibility of new facilities and how, I guess, Kempner did not want to pay for those. And so you come down really to this phrase in the contract about this, where you're talking about the cost divided by the number of customers, and it says received by all of Central's customers.
Sure.
So if the intent was to limit the customers just to the old plant or the existing plant, I mean, why wouldn't the contract have said that? I mean, it could have said that, right? It could have said
sure.
all of the existing customers or all of the customers of the old plant. And so I guess that's what I'm struggling with. You can address
Sure.
that.
Fair enough. And that's really Kempner's point, argument, I believe. Well, first of all, sure, could it have been said? Yes, it could have been said. But here's the thing, Judge. It was the only plant that existed and the only plant that ever existed. I mean, it was their plant. It was the plant. And the evidence shows that Kempner was building its own competitive plant at the time. So there's nothing in the record to indicate that, other than to say, we're not going to pay for anything. There was nothing in the record to indicate there was any contemplation of new facilities that would apply to these provisions that talk about a reasonable proportionate payment for O&M and water treatment costs. It could have said it, but it's one of those things. It's like, I was trying to think of a good analogy last night. So I enter into a contract with you. You have a house and you have a beautiful 100 by 100 foot front yard. And I enter into a contract with you for the next 5 years to cut your front yard, to mow it once a week for $20. And we go along every week. I mow and you pay. And then year 3, you go buy the lot next door, move your fence and all the furniture over there, and suddenly your front yard is much bigger. And I come over and say, well, and you say, please mow the rest of it. And I do. And I come and I want more money. And you say, no, the contract just said, mow my front yard. Now you could have said, if I ever buy more, it's going to be different, but it just says mow my front yard for $20. So as much land as I can buy, you're just going to have to keep mowing it for $20. So what we would do is what we are urging the court to do here is look at the circumstances that existed at the time the contract was signed. And under my little analogy, I think the court would look and say, well, what was meant by mow the front yard was the 100 by 100 foot front yard. Here, there was no reason to say from the water treatment plant because it was obvious that that's all there was. That's all there was.
Was there any evidence in the record that Central had already secured land by this time to build a new facility?
Yeah, they had. And Kempner, the 53% player, said, we're not involved. We're going to do that. We're going to go build. Not only are we not going to participate in something like that, we're going to go build a competitive water treatment plant. So the conditions that existed at the time were that certainly there was a piece of land, but Kempner was not only not going to participate in it, they were going to go build their own competitor, and they could reduce their way out of this contract. So yes, there was land, but nothing was going to happen with it.
So, but I guess the point is at least there was kind of more than the theoretical possibility that Central could build a new facility. They had secured land, and there was some active discussion of it, I take it.
There had been,
okay.
But again, here comes Kempner. Everybody else, these other small cities, maybe 2 to 3%, and here's Kempner with 53%, and it's going to go build its own competitor. So there's nothing in the record to show that there was any expectation that any other facilities would be built. The only mention of new facilities was in the context of Kempner says, we're just paying for this unit that is the subject of this contract. What is not in the contract, Your Honor, is language that says over the course of time, Kempner can take water and incur, say, 50% of the cost of the operation of the plant, but shift 10% or 8% of the cost of that over to the other members. There is absolutely nothing in the contract that says, hey, We, as the other members, who are the majority of the board, have included in the contract some language that says that if something happens, Kempner gets to shift its expenses, portion of its expenses, and we have to pay for it, that we end up subsidizing them. There's nothing in the contract that says anything like that. So for a period of 7 years or so, Kempner paid this way, exactly as we have discussed it, used 45% of the capacity, paid 45% of the expenses. But in 2009, and this is really, I just want to set the setting for how the dispute arose. In 2009, of course, we're all aware of the Great Recession, and 2008. And in 2009, Congress approved some stimulus funds for building of public projects. Certainly unforeseen in 2005. There's no evidence in the record, and I think the court could probably take judicial notice. We didn't know the Great Recession was coming. These stimulus funds were made available at 0%, unheard of, 0% interest. The Water Development Board in Texas received some of the money, and Central Texas, the other members of Central Texas, at a 0% interest rate, made an application, and it was awarded to Central Texas. And a smaller plant was built, called the Doc Curb. He was an important man in the history of Central Texas. It was built, and totally at the cost of the others. Operation and maintenance paid by the other members, not Kempner. Water treatment costs paid by the other members, not Kempner. And that was put into in the system in 2012. In 2017, the general manager discovered that the water from the new plant that was paid for solely by the other members, maintained by the other members, all costs paid by the other members, that water had been inadvertently, through administrative error, put into the denominator of all water provided to all customers. So the effect of that was to reduce the O&M and water treatment cost of Kempner below its actual cost. Remember, 2.03 said we'll pay the actual cost. So rather than using 45% of the water and paying 45% of the O&M and 45% of water treatment costs, which is the fair contemplation of the contract, Kempner might have taken, say, 45% and only paid 36% of the cost, not paying the actual cost. In effect, what was happening is, because of this inadvertent error, the cost, that additional cost, was shifted to the other members, and they ended up subsidizing Kempner. So rather than paying for what it took, it paid less than for the cost of what it took. There was a discussion between the general manager and Kempner's general manager trying to work this out. It did not get worked out. The long and short of it is that in February of 2018, the board of Central Texas voted to reestablish the relationship as was intended in the original 2005 contract. And so the amount of water delivered to all customers from the water treatment plant, which is the only plant that existed, might have ever existed, in 2005, that water is measured as it comes out of that plant. So every drop of water that's delivered to all customers out of that plant is measured there at the plant. That's significant because there's evidence, I believe, in the record that a certain percentage of water is just lost between a plant and when it's delivered to a customer, just a natural leaking and so forth. So the board said, look, the maximum amount that could ever be delivered to all customers out of the plant is at the plant meter, and so that's what we're going to measure. The bills were calculated in that way in accordance with the original intent of the contract, and Kempner has declined to pay it. So that's our controversy. So it is clear from a reading of the 2005 contract that the water treatment plant and the existing treatment plant are the unit. That is the subject of the contract. And Kempner is to receive water and to make payment from that unit and to make payment for its fair share. It is clear from a reading of 2.03, which says we'll pay the actual cost of the treatment of water. And the way it's calculated, and 2.05, in light of the circumstances that existed at the time the contract was signed that Kempner pays its fair proportionate share. It's significant too, I think, to note that there are other indicators of proportionality in that contract. For example, if the capacity of the water treatment plant were to be increased by some sort of regulatory edict, then Kempner gets its percentage increased proportionately. If, on the other hand, the capacity of the plant is reduced because of function or regulation, then Kempner's percentage is reduced proportionally. It's all a unit, it's proportional. If there's a water shortage and the plant can't produce the amount of water that it's 14.35, then Kempner's is reduced proportionally. So the whole note of the contract, as it was intended and when it was signed in 2005, is one of proportionality. And that's what 2.03 and 2.05 call for. The only mention, and it is clear that the term new facilities is mentioned, but the only mention of it is in the context of we're not paying for it. We don't have anything to do with that. The parties agree that the contract is unambiguous. The relevant intent, Your Honors, is the intent on the day the contract was signed in 2005. And in light of the circumstances that existed on that day, and in light of the fact that the subject of the contract is that unit, that existing system, then the only interpretation, we believe, the correct interpretation is that Kempner should pay both water treatment cost and O&M cost based upon the amount of water it takes as a percentage from the water treatment plant, which is where it takes the water from, as a percentage of all the water taken out of the water treatment plant. In that way, it pays its actual costs. It pays its proportional cost. It is in line with all the other proportionality provisions of the contract. Very briefly, I just want to touch very briefly, Kempner has asserted some affirmative defenses. And that would be saying, okay, you may be right, but if you are Central Texas, then you've either ratified this or you are stopped. I want to say, first of all, that neither ratification nor estoppel are defenses to a contract interpretation claim. These affirmative defenses apparently arise from the billing clerk's error and are not even, actually not even relevant. So, Your Honors, we would ask the court to reverse the trial court's judgment in favor of Kempner and Lampasas, to order that Kempner and Lampasas take nothing. In any event, in accordance with our briefs, to direct that the intervention filed by Lampasas be stricken and that Lampasas be stricken in the party, and to render judgment in favor of Central Texas as prayed for in its petition, motion for summary judgment, and brief.
Thank you. All right, McSwain.
Thank you, Your Honor. I was muted. Am I off mute now? Can you hear me?
We can hear you. Thank you.
Perfect. Thank you. May it please the court. This case involves two specific billing formulas in paragraphs 2.03 and 2.05 of the Kempner Central Texas water supply contract. It is apparent from reading the contract that it was a highly negotiated contract. It goes into excruciating detail in the definitions and in the various paragraphs that go throughout the contract, including 2.03 and 2.05. And the fact is, the objective circumstances at the time, which is what Mr. Olson in Central Texas wants you to review, are that this was an agreement between two parties that had done business for almost 20 years at the point that the contract was entered into. It was to settle a billing lawsuit, a lawsuit over billing practices. There were sophisticated parties that had been in the water business for years. They had sophisticated lawyers, a room full of lawyers for each of the two parties. It was an 80-year contract. And as you would expect with a room full of lawyers and an 80-year contract, as Justice Alley pointed out, it contemplates new facilities. And if you look at the definition of new facilities in section 1.01 of the contract, it specifically mentions new water treatment plants. And it is admitted in this record that the dock curb plant, that was the new plant that came online in 2012, is just such a new facility. And it is admitted in this record that Central Texas had owned the 78 acres at the site of that plant for some period of years prior to this, and that there was a plan that ultimately had gone by the wayside that was resurrected when Mr. Olson's cheap money came available from the government. The fact is that this was a fair contract when it was signed. It was fair to both sides. You'll see from bench exhibit number 2 that there are a number of obligations of Kempner, separate and apart from simply paying for the water that was treated, that it received. But one of the significant protections that paragraphs 2.03 and 2.05 put into place contemplated the future, contemplated new water treatment facilities, contemplated the fact that at some point Central Texas would have the ability to move customers and customer water volume away from the plant that was servicing Kempner, this old plant, or what's called the water treatment plant. So in paragraph 2.03, the exact formula, the fraction that is to be applied to the actual costs, is specifically set out, and it includes the total volume of all customers. And in 2.05, with respect to the O&M expenses, the operations and maintenance expenses, the same thing. It specifically says the total volume of treated water delivered to all customers. What that does is it protects Kempner from the manipulation of its expenses by the transfer of water or water volume or customers to other plants. And as a matter of fact, we have in this record, in Lee Kelly's deposition, admission that that's exactly what's happened with respect to the dock curb plant. They have moved based on Central Texas economics, based on customer demand. They've moved customers to the dock curb plant, and they've moved water volume when they want to over to the dock curb plant. If this type of protection, the total volume of treated water delivered to all customers, was not in place, Central Texas could effectively manipulate the expense load paid by Kempner simply by moving water around between its various water treatment plants, which were contemplated in the new facilities definition of the contract itself. And there is protection for Central Texas in the contract as well. In the course of moving those expenses, in the course of moving that volume around, Central Texas is protected because there is a minimum charge that Kempner agrees to pay. There is a minimum charge. It's 42% in paragraph 2.05, so that if Kempner takes 35% of the water out of the water treatment plant, then it doesn't pay 35% of the expense, it pays 42% of the expense. And so Central Texas is protected in this shifting volume and customers around between the new treatment plants that may come into service in the 80-year term of this contract. Central Texas is protected because it has a minimum floor of expenses that Kempner will always pay, regardless of the amount of water that it takes out of the water treatment plant. So these paragraphs are written this way for a reason. And indeed, the court must presume under El Paso cases, under Supreme Court cases, the court must presume that the parties used the words that were used in the manner they were used to achieve the end that they contemplate expressly. And expressly, these two paragraphs say, it is very clear, the total water delivered to all customers is the denominator of the fraction that is applied against the actual cost in paragraph 2.03 and the actual operation and maintenance expenses in paragraph 2.03.
So, Mr. McSwain, can I jump in here and
Yes,
just
ma'am.
generally make sure I understand how the formula operates? So it seems as if as the customer base grows over the years, then that would cause the denominator to be larger and larger. And as a result, then Kempner would gain some advantage because the price is now going to be reduced over time. Is that right?
In theory, that may, and I had to look up numerator and denominator, frankly, to make sure I got the right term for the right thing. The numerator is the amount of water that Kempner takes, right? The treated water, and the denominator is the total volume of all customers. Plain as day. In theory, you're right, but we also don't know what Kempner's increased demand might be over that 80-year term. And so it could fluctuate from time to time. But the fact of the matter is, and if you look at our bench exhibit number one, I'm sorry.
I'm sorry, but can I
Yes,
throw in another subpart to the question?
Yes, ma'am.
So as the customer base is growing, then it would just mathematically, in theory, cause the price to reduce, yet aren't there several provisions in the contract that protect Kempner from participating in carrying the load of any of that cost?
So there are provisions in the contract where Kempner, two sets of provisions, where Kempner is not paying for new facilities. And you'll note that neither paragraph 2.3 nor paragraph 2.5 make that an applicable inquiry in the amount that Kempner is actually scheduled to pay. But the other thing is that any modifications, and so that you know, the record is pretty clear that most of the customers of Central Texas receive blended water of some sort. Blend water that comes from both the water treatment plant and the dock curb plant. So it's blended in the transmission system. But one of the things that the contract also makes clear is that if Kempner needs modifications to the system and requests those, for instance, what if Kempner has increased demand, right? If Kempner needs modifications to the system, then Kempner pays the entirety of those modifications, whether or not the other customers also benefit from them. And so there are a number of kind of pushes and pulls in the contract where the parties have different obligations.
So where's that coming from specifically in the contract, that provision?
That provision, I believe, is, oh, shoot. That provision is in, I want to believe that it is in paragraph 2.01B, labeled improvements. But honestly, mine is little bitty, and I'll have to double check that. If it's not right, I'll let the court know, but I think that that's correct. If you look at bench exhibit number 1, and if you listen carefully to Mr. Olson's argument and look at their briefing, what is clear is they have, in order to make their argument work, they have to add words to the contract. And if you look at our bench exhibit 1, you see in red the words that they have to add that are simply not there. And the excuse for that is that somehow the objective surrounding facts and circumstances require that. But as the Texas Supreme Court has made clear in this Barrow-Shavers case from 2020, and honestly, this is not new law, it's decades of Supreme Court law, the Barrow-Shavers court specifically said surrounding facts and circumstances cannot be employed to make the language say what it unambiguously does not say, or to show that the parties probably meant or could have meant something other than what their agreement stated. And this court, within the last month, Justice Palafox wrote in the, in this MRC Permian Company case, the surrounding, this is what this panel said not a month ago. The surrounding facts and circumstances could inform the meaning of the language in the agreement, but could not be used to augment, alter, or contradict the terms of the contract that are actually there. And that's exactly what they have to do in order to make their contractual argument work. is to add words to the contract and limit the denominator of the fraction. The fact of the matter is, if you limit the denominator of the fraction, then what you do is you wipe out the very protection that Kempner has from the manipulation of volume and customers to drive the Kempner expenses upwards. That was a negotiated provision of this agreement that benefited Kempner, just like the minimum benefited Central Texas. And I will tell you, in case there's any question about it, in the record, at sites, the record cites 499 to 501, and then again on page 513 are the deposition excerpts of Lee Kelly, where he says that at least 2 customers were moved to the dock curb plant and away from the old water treatment plant. And more than that, where he says that the economics for Central Texas and for its customers are what drives where the water volume is produced. Finally, to the extent that they want to add terms to the agreement, for instance, water treatment plant in both of these, please note, for instance, that in paragraph 2.03, the term water treatment plant, not only is it defined, but it's actually used in paragraph 2.03 in another place. And so my question is, if they used it in one place in 2.03, why couldn't the room full of lawyers put it in now where Mr. Olson wants it put in otherwise? But they didn't. And the same thing is true for paragraph 2.05. I would ask that the court affirm the trial court judgment and not allow the change of the contract as requested by Central Texas. The rest of my time goes to Ms. Keeney. Thank you.
Thank you, Mr. McSwain. Ms. Keeney. You're on mute.
Nope.
Am I?
You are, now we can hear you.
Okay, it wasn't showing that I was. I'm sorry, I apologize.
You might want to turn up your volume because your voice is really soft.
My partners tell me I'm too loud, so I've got to get to me.
You're fine. Thank you.
Okay, may it please the court. Lampasas intervened in this dispute because the Kempner contract is an essential component by which Lampasas receives the water that it has to have in order to serve its residents. Lampasas actually has a 3-way contract with Central Texas and the Brazos River Authority, under which Lampasas has assigned to Central Texas its water rights so that Central Texas can deliver that water to Lampasas via the Kempner contract. In fact, that 3-way contract requires Central Texas to enter into the Kempner contract. And Lampasas's contract with Kempner requires Kempner to enforce the Kempner contract with Central Texas and prohibits any unconsented to amendments to that contract that could affect Lampasas. Exhibit 8 in the handout that we filed with the court the other day shows that the Lampasas contract has paragraphs that mirror the language in Kempner's contract with Central Texas with respect to the costs that are at issue in this appeal. Now, Kempner, that's because Kempner passes through to Lampasas most of those costs. So resolution of the meaning of these costs in the Kempner contract will determine their meaning in the Lampasas contract as well.
Counselor, if I may, I mean, ultimately all the costs are passed along to the end consumers. So just, I don't know how many people live in Lampasas, but could an individual person in Lampasas intervene in the suit to suggest that they are ultimately carrying or paying the charge or any overcharge?
No, Your Honor. I think there's a case we discussed in our brief, and I can't remember, I think it's out of Corpus Christi, where it said customers can't intervene, but the actual entity, which would be Lampasas, which does have a contract with Central Texas and does have a contract with Kempner, that and does have in that essentially the standing to force compliance with the Kempner contract by Central Texas. I think there's can't really be any serious question that we have a justiciable interest in this case. I think the trial court properly exercised its discretion to allow us to intervene. All we needed to show is this justiciable interest. We briefed that, well, I think it was more than 10 pages in our brief, and Central Texas said nothing in its reply regarding our briefing on intervention. And, you know, unless the court has further questions, I would rest on our brief on the intervention issue. We don't think our customers could have, but we certainly had the standing to intervene and would be adversely affected by the outcome of this case by virtue of how it will affect our contract with Kempner. All parties to this case need to know whether all means all. Central Texas accepted the fact that all means all for 12 years, including 5 years when its new plant was operational and it had moved many of its customers to the new plant. Mr. Olson suggests that was an administrative error, a 5-year administrative error. That's really not credible. Their change in 2017 and 2018 to different billing systems, and they tried one and then they tried a different one, are nothing more than an impermissible attempt to retrade the deal that it made with Kempner in 2005 and on which Lampasas relied when it negotiated its own contract with Kempner in 2006. The rules of contract construction confirm that the trial court was correct here. The first rule to consider is the plain language rule. In URI versus Clayburgh County, the Supreme Court tells courts to apply the plain, ordinary meaning of words unless the contract directs otherwise. Nothing in the Kempner contract directs otherwise with respect to whether all customers of Central Texas or total gallons of water received by all those customers means something other than total water and all customers. The next key rule that supports the trial court's decision is the rule requiring courts to look at the contract as a whole. The Kempner contract addressed the possibility that Central Texas might later add new facilities and required different treatment for the existing system and any new facilities. Now, Central Texas suggests that means the parties didn't intend to include customers served by the new dock curb plant. We think that, on the contrary, we think the opposite inference should be drawn from this. As Kempner's counsel pointed out, the opening language of these two paragraphs mention the cost of the plant, and basically Kempner will only bear the cost of that plant. But when they got down to calculating the formula, they protected Kempner and Lampasas from the manipulation of moving customers to a new plant by requiring all customers to be part of the calculus. This was a comprehensive contract, and if the parties didn't include that language in the proration formulas, this means the parties didn't intend for them to be there. That's supported by this court's decision in Duncan versus Woodlawn and several other Supreme Court cases that we cite. I think it's around pages 21 and 22 of our brief. The contract construction rule that prohibits adding words to a contract also defeats Central Texas's position. The only way their interpretation works is you either add the terms existing system and water treatment plant to the calculation provisions, or you imply them. The Supreme Court said in HECI Exploration versus Neal that the only exception to the prohibition against adding words to a contract is the rule that allows additional terms to be implied when those terms are a necessity. There's no necessity here. Central Texas compliance with this contract in its plain language for 5 years after the dock curb plant became operational confirms the absence of any necessity. At most, their argument is that it'd be a more balanced agreement if they didn't have to count all of their customers, but a balanced agreement isn't enough. Should I stop, or can I have just another few seconds? I'm out of time, so.
You can finish your thought, Ms. Keeney.
Okay. The surrounding circumstances rule, the Barrow Shaver Resources versus Carrizo case makes clear that surrounding circumstances cannot be a basis for adding or changing a contract's agreed terms. And that rule applies with particular force here because the surrounding circumstances are that this contract was the product of negotiations between sophisticated parties represented by counsel to settle a litigation billing dispute. We respectfully request that the court affirm the trial court in all respects.
Thank you.
Thank you.
Mr. Olson.
Thank you, Your Honor. Nothing in this contract, and the fact that there were lawyers involved, I mean, that shouldn't surprise, I was one of them, it shouldn't surprise anyone. Nothing in this contract even hints of this fee shifting. We got a room full of lawyers and everybody, there's nothing in this contract that even hints that Kempner's using 45% of the capacity of the plant in a given month, that Kempner would not have to pay its fair, business-like proportional share. There's nothing in this contract that says that. I come back, Your Honor, to my example about mowing your front yard. So I have a contract that says I will mow your front yard once a week, and then you expand it. And someone says, well, you could have said, put some legal description there, meets and bounds of what the front yard meant. But we looked to the circumstances that existed at the time the contract was signed, and we can tell what the front yard meant. It meant your front yard the day we signed it, and it was 100 by 100, not 2 extra acres. This, and we're, by the way, not adding words to that contract, just determining the intent of that contract, what was meant by front yard. This business about manipulating the system is kind of a recent construct, and it's a pretty big claim. To make this claim work, that somehow this provision was put in here to keep some sort of nefarious, abandonment of the plant to Kempner, would require that the other members go out and spend $20 million to build an additional plant to accomplish that goal. These are the city of Lott, Texas, and East Bell Water Supply Corp. This is not IBM and Dell Computers. These are small entities. There is no evidence that anything like this has happened, that somehow Kempner is being abandoned in this plant to pick up all the expenses. By the way, the expenses would only be the expenses incurred to treat their water. Nevertheless, there's no evidence of that. And the only evidence is that Kempner itself reserved the right to leave that water treatment plant to the other members. So on the one hand, it is saying, we must have done this to protect us so that the other members didn't abandon this to us. But what they don't say to you, oh yeah, by the way, we negotiated into the contract a provision that says we can do that to them. That's in the contract, and they have. And the third thing I think is important is we're not talking about pink champagne here that just might be used by somebody. We're talking about drinking water, the most essential element of life, in one of the moderately fastest growing areas of the state, maybe the country. It's not like the notion that Central Texas is going to have a water treatment plant with a 14.75 or whatever it is, a million gallons a day treatment capacity, and just walk away from it for the purpose of making Kempner pay the expenses is nonsense. This is water. This is drinking water. There's not enough of it. So I'm sorry, please. I'm
sorry, Mr. Olson, may I interject here and ask you to respond a bit to Ms. Keeney's argument? Because obviously we are bound by Supreme Court precedent and our own precedent. Are you asking that we imply the term existing customers because it's a necessity to do that? Or are you saying that that wouldn't be adding any words to the contract?
It's not adding any words to the contract. It is the intent of the contract. If you look at the four corners of the contract, the subject of it was the existing system and the water treatment plant. And the customers served out of it. I mean, that was what existed at the time. It's my front yard. That's what it was about. It's only about that plant. It's only about the existing system. And when we say customers, there were 12 years. The first 7 of them were served out of that plant. And this was all done and paid exactly as it intended to. And where it got thrown off was this other water was added in. We're not asking you to add terms to anything. We're asking the court to interpret the intent of the contract. To do otherwise is we think is unreasonable to the level of being absurd. And you pointed out that over time, if on the investment of the other entities to build, because they got this loan to build this other plant, and the cost of the other entities over time, Kempner's share, even though it's maybe using 45% of the capacity, incurring 45% of the expense, its share progressively gets smaller. So thereby shifting the cost to the other members. There is nothing in the contract that even hints of that sort of thing. So what we're asking you to do is look at the contract as it existed in light of the circumstances that existed in 2005. And they're all sort of, we all have our favorite contract constructions, but an absurd result is abhorred. An unreasonable result is abhorred. One of the things that neither Kempner nor Lampasas ever touch base on is why? What reason would anybody have for doing this? And just, sure, let's just shift the cost to us. And remember, all the board, except for Lampasas and Kempner, were the board members who voted for this were the other people. So what would the reason be? Yes, sir.
I understand this was settlement of a lawsuit, and the contract came out of that. And so sometimes you settle a lawsuit because you have to, and you'll take any deal that's on the table, or sometimes you settle a lawsuit because you're in the driver's seat and you can dictate the deal. But we have there's nothing in the record that kind of tells us which position the parties were when they negotiated this contract as a settlement of that suit. So, you kind of keep talking about the circumstances, but wouldn't one of the circumstances be kind of who is in the driver's seat?
Well, that cuts both ways, Your Honor. But I would just invite the court to read the contract, to just read the contract. Because when you read the contract, you will see that it is about the water treatment plant and the existing system. And there is nothing in there that comes anywhere near. And the only reference to new facilities is Kempner says, we're not going to pay for them.
So when I'm sorry, Justice Allen, were you finished?
Yes, ma'am, please.
All right, so by reading the 4 corners of the contract, though, I see that there's many places where there's distinctions being made between customers and new customers, and existing facilities and new facilities. So it's difficult to try to figure out how to reconcile when you read that one single line that tells us that the denominator is all customers, when there is distinction made in the contract between new customers and existing customers.
Well, I'm not quite sure what the court's referring to in terms of customers. There's a definition of new facilities. And that definition simply says, we're talking about the subject of this contract is the existing system and the existing water treatment plant. And Kempner's paying for that. By the way, 2.03, the first sentence says, we'll pay the actual costs of treating and delivering water. But there's reference to the term new facility. It's a defined term. And it's used to say, that's not a part of this contract. We're not paying for any of that. So again, we would say, look at it in the context of what existed. It's clear from the contract, really. We don't have to get any outside evidence, but we have some. What existed was this one plant. Yes, ma'am, I'm sorry.
Mr. Olson, my question is if you could respond to the claim or allegation of your client being able to manipulate the number on the denominator. If the court were to construe the contract the way that you're advocating, and if it were to move the customers away from the old plant over to the Doc Kerr plant, isn't that a way of manipulating the formula so that Kempner and the city of Lampasas pay 100% of the costs at the old plant?
Well, first of all, Your Honor, first of all, to do that would mean that all of the water that's treated out of there,
right?
at least half, wouldn't be used. I mean, it's a nonsensical argument because water is in great demand. Is it possible? Well, to follow that theory, that speculation that Kempner and Lampasas have cooked up here, would mean, first of all, that everybody else would have to incur this huge expense for that purpose. So they're in the business, Central Texas is in the business of selling water. So there's no motivation on the part of Central Texas to not use a water treatment plant to treat and sell water. Again, there's no evidence that this sort of thing has happened. Have some customers been moved over? Sure, because it's easier to serve them from the other plant, which then opens up opportunities to bring customers to this plant,
Right.
for this water.
So the numerator and the denominator it's the number of gallons. It's the number of gallons that Kempner Water it buys, divided by the number of gallons that the plant puts out
Produces.
on a monthly basis.
Yes,
Producing.
ma'am. Yes, ma'am.
So the only way, okay. So the only way you're saying that it could be manipulated then is if I mean, if they're only getting 50%, then it's and there's only one, and 50% is going to be 50%, regardless if they're the only customer or not, right?
Right. So if all of the water, let's just say that circumstance exists, and there's no evidence it ever has.
Okay.
And it hadn't, but let's just say that this construct that they've come up with existed. If the water plant produced 1,000 gallons and it was all delivered to Kempner, then Kempner would pay, the cost because all of it was delivered to Kempner.
Right.
But I mean, that was, that's the intent of the contract. But again, that's never happened. And I can't imagine a circumstance where it would. We got a fast growing area of Texas that needs water. And so for this construct that they've come up with to work, it would mean walking away from a huge water treatment plant that provides drinking water to a fast growing area and say, no, I'm sorry, we're just not going to sell any water to anybody, just to spite Kempner for some reason.
No.
There's no evidence of that. And I've got to remind the court, it was Kempner itself who reserved a right in the contract to walk away from that plant.
All right.
Because they built another one.
Thank you very much, Mr. Olson.
Thank you.
We really appreciate your arguments this morning. The case will be submitted based on your briefs and excellent presentation. So thank you so much. We appreciate it.
Thank you, Your Honor.